You mentioned the ethical guidelines of the bar, and I'm in behavioral health, and on several of the ethical guidelines for the various disciplines, it says you really can't advertise. If you are to advertise, it's simply a replication of your business card. And so then I will see a psychologist or somebody put out an ad, come get your anxiety treated, you know, or fixed. And so does that
file a complaint. Yeah. Yeah.
Would that fall into this area of false ad? I mean, it's not like, I don't know what
it's a category of it's a violation of the standards for that business as licensed in the state, right? That's where it would fall.
Yes.
So every industry has kind of a, well, all professional organizations like that have a licensure board that talks about the standards for advertising in that. Same with the bar. And so that would be a matter, it's not false advertising, it's obviously if it could be false advertising. If the advertising says, come get your anxiety healed or fixed, you know, and or we're the best in Atlanta, maybe that's puffery, but if they said something like 40% of our patients are healed within 6 months, right, or something like that, it could be false advertising in addition to being a violation of the regulatory structure that governs that profession.
Well, I can't help but wonder if about the competition though too. If everyone else is following along and they don't boast anything in the ad that's false, but they're doing these ads that are considered unethical, then I wonder if someone else would have a lawsuit saying that it's unfair.
I think
if it took the state 6 months to, you know, respond to the licensure violation.
You mean they might have, again, paid for the problem by the 6 months they got of the advertising and the competitive advantage? You know, those licensure boards are very tricky. We've dealt with the architectural board, the engineering board, the bar, and they're all very particular and have different rules that govern the structures of those organizations. But I suspect that a claim can be lodged. The body could probably take its own action, but unless it's alerted to something, it may not know. But I mean, that would be a recourse for a competitor to go there. That would be an inexpensive way to have that body say, hey, stop that. That's not within our rules. Yeah?
Can someone come after you for something that you're not running anymore? That you ran 6 months ago?
It wouldn't be a current claim, but what you can find is, and this is a great question because it goes to when damages are available in these kinds of cases. The statute of limitations is not limited to the period of time in which the ad is running. So yes, a claim could be brought for damages. It wouldn't be for injunctive relief because that would be moot. But if you had a 6 month period where an ad ran and you noticed afterwards that there was a corresponding decrease in sales in a certain area and the allegedly problematic company or falsely advertising company, their sales go up, if there's a corresponding metric like that, you can show it, and you can also show that the ad was false and misleading, then sure, there's no reason why an action couldn't be brought. I haven't seen one of those before. You don't see them very often, but I don't know of any reason why it couldn't happen.
Shay,
yes.
Celebrities. What's the rule on whether or not they have to use the product? Tiger Woods, for example, endorses Buick. Does anybody really assume that he's driving Buicks?
Only if he says he is. He doesn't have to. If he says he is.
He says in the commercial he drives one and he has one. Yeah.
It depends on the content.
How far does that go? I mean, how much do they have to? They have to use the product they do. They have to drink the. I mean.
Only if they say they do.
Okay.
You know, they don't have to if they're not saying they do. If they're just talking about the benefits of the product, they may or may not be a user of the product. But if they say if he says he drives a Buick, then he better be driving a Buick. So yeah. At least once, right? He has to have one in the garage with the other 20 or whatever.
With the Gulf Stream.
Exactly.
How much does he actually have to drive?
The FTC says he must drive it for 20 hours a week.
What about like for my product, sell your independent reps? What if they?
Well, what is your product?
It's industrial steam boilers.
Okay.
So if they make a claim that's false, about our product, are we liable?
No. Well, it's a good question as to the scope of liability. Generally, in that scenario, you wouldn't be, but within their organization, if they had an ad agency, the ad agency can be liable, the advertisers can be liable, and the individual people responsible for the false advertising can be hit too. So I don't think it would extend to you if you literally had no say in the ad. It would tie back to whether or not you had authorized those statements. If they made them up completely out of whole cloth and you could prove that, then I wouldn't think you would have any liability. You might get sued, but you wouldn't have any liability.
What about in different mediums now? Maybe something that's not that class of advertising medium.
Well,
just website to website, for example.
Well, and it's another great point about social networking. Sorry?
And Google Ads.
Google Ads.
Representing those people that buy those ads, like sometimes your own name.
Yes.
Not you.
That's a huge topic right now. It's not a false advertising topic as much as it's a trademark infringement topic. But that's a very, very hot topic. And, well, to answer your question first, the FTC has recently come out with a new statement. Again, there's a wealth of information there, but there's a new statement about the implication of online activities. And essentially the FTC came out at the end of last year and said, for any of you who think the old rules don't apply, they do. And they restated that rule that I put at the beginning of the presentation. They restated and said, here is the rule, and we're still going to enforce it, whether it's in an online situation or not. And so then they went through and said, here's a basic guideline for all of you out there as to what you can and can't do in an online environment. Now, I will say one other thing. The most interesting online issue that we're seeing is this concept of the shill, because social networking has been struggling with this issue of, and this goes to the implied endorsement issue of when a company employee or officer has a Facebook site, is that person speaking, if they're talking about their product, are they speaking in their individual capacity or are they speaking as a company representative? And bottom line, the FTC, again, has come out with very strong rules about the fact that if you're saying something about your company, you better be making a disclaimer, an acknowledgement that you are speaking in a professional capacity. If it comes out that there's this concept called sock puppets. There are sock puppets. Sock puppets are people who've created a false identity. Anybody know what sock puppets are? Yeah. Okay. Well, that's the real sock puppet. But a sock puppet in Facebook is somebody that creates a false identity to create the idea that they are a regular person who's out there talking good about a product, saying good things about a product, and they're actually not. It's a false identity. That's not legal, obviously.
What about a mascot with an identity on in social media?
A mascot.
That doesn't exist. It's a talking mascot with an identity.
Yeah.
That is the face of
like
the
the
company.
Pillsbury Doughboy.
Yeah. Well, I wouldn't think the
Social media with, for example, a Facebook page.
The good news about the Pillsbury Doughboy or a mascot is that there's no question that person is a spokesperson. Entity is a spokesperson for the company. So there's no question as to this line between, the false. There have been all these cases where reporters, it turns out later, were paid by the company and so forth.
Like bloggers.
Bloggers, right. If you don't disclose that, you could be charged with false advertising. Or the advertiser could be charged with false advertising. So, Rena's coming over here, so.
Well, I want to get everybody back to
Yeah.
But I
She met
appreciate.
us when she said
Yeah. Really, everybody needs to know. They need to get back to work. No, thank you very, very much for coming. We'll just hang around, have more coffee. There's more to eat if you want to. But we're going to have more of these kind of sessions. Is this good?
Yeah.
This is
Good.
I enjoy
Thanks.
it. So we'll just continue to have more of these kind of sessions and invite you. And we'll have bigger and better and more food. But, because food always sells. Anyway, thanks for coming. Hang around. Jay will be here for a few more minutes.
Sure. Thanks, Rena, for having me.
We'll continue to talk. All right, thanks, guys. Appreciate your
Okay,
time.
thanks. Thank you.
Those of you who want to go on a tour, call me. I'll tour you around.